Okay, so then you have to submit a certification listing the assets. The real estate, if there is any, personal property, any finances, the stocks, the bonds, bank accounts, receivables, etc., liabilities and debts, and now you have to put down income. Sometimes you used to see that, sometimes you didn't see it, but now you have to list the income that the alleged incapacitated person has. The certifications from physicians, no change there that I can see. It's you need 2 physicians, or you can have a physician and a psychologist. You have to have it has to be a recent exam, has to be done within 30 days of the date that you file the application. But sometimes you miss it, and we've missed it. So if you submit a certification indicating that asking the court to relax the court rules, if the person has dementia, has had it for a long time, and there's very little, been little change in the person's condition, we've never been rejected, and we ask the court to relax it. It has to have a separate certification. I think I included what we use in the appendix with the materials. And here's what the doctor has to submit. I have a doctor's certification attached. Ours have always been accepted, so they have to outline the extent to which the alleged incapacitated is unfit and unable to govern themselves. Usually they're conducting an examination. They don't have to write a book about their findings, but it's usually good to give some summary of what they discovered through this exam. Some people conduct all kinds of tests that they have. They can attach that, they can describe the results of the mini mental status test or other tests that they use. And that gives the court a foundation that they need in order to find somebody incapacitated, if that's what they're going to do. If there are any areas in which the alleged incapacitated retains capacity, they're supposed to list that, and you're supposed to have that on your certification so they can indicate that. I've never really come across that with the majority of times there isn't any areas where the alleged incapacitated retains capacity, although sometimes younger people, disabled people, that will be the case. And also have to say whether the alleged incapacitated person can attend the hearing, and some of the judges want the person to attend if they're able to. And then you have this new form. You never had to do a case information statement in any of the courts that I'm aware of before a guardianship action. Now you have to prepare one. It's odd because in all the other pleadings, you're supposed to certify that confidential personal information like social security numbers have been redacted, but on this case information statement, you have to include the person's social security number. So maybe that'll change, but that's the way it is now. And in other respects, it's a lot like a typical case information statement in other litigation. So you you don't have to file the judgment with the pleadings, but you're supposed to file a proposed judgment within 10 days of the date of the hearing. And this will give you an idea of the timeline. So you get a filed order fixing a guardianship hearing. What do you do with it? First, you serve the pleadings on the court-appointed counsel, right? The name will be listed in the order. You serve the counsel. You may want to call the counsel up. They most likely, in all cases that I've had, they've been informed that they've been appointed, so they're probably waiting for them. And then within 20 days of the hearing date, you have to serve the pleadings on everybody else, on the alleged incapacitated person, and then there has to be a notice that the AIP can appear, can oppose, can demand a jury trial. For years, we had a notice given. We had personal service by a subpoena server on the alleged incapacitated person, and there was also a verbal notice. When you hand the papers to the alleged incapacitated, there was a script, really, a notification. There's a guardianship being filed, who was filing it, what their rights were, and then the subpoena server would sign the certification, and we'd file that too. I don't see that that's required anymore. It's probably good practice, but it seems like what is required is just to make personal service just like any other complaint. Okay, and then you have to serve obviously you have to serve the papers on the next of kin, anybody listed in the complaint, any parties in interest. Then you have to file proof of service.